Yeah, please. With the
Yes. Sorry, I was assigned some official work for which I had to sit late. Yes,
with the consent of petitioner,
13. It's a review petition. Review petition, I'm not adjourning like that. It's 2019 review. You can't sit over review petitions. Just wait till the matter is called. Renew the prayer when the matter is called. Yes. Listing, please give it to the court master. He'll have to take a call.
Item to Prera, I think.
Huh.
I have taken counsel to the other side. Where Senate take the.
Pardon me?
Can it be listed after vacation? It has already been admitted. Item 2.
Okay. UFO?
And the response.
Okay. You have taken consent for the other side? Okay. With consent with the other side, Mr. S. Biswas, counsel for the respondent caveator. Place for adjournment. Here is allowed. List. After vacation, give a date. Give you a date. There's an interim order operating.
No, but it has been admitted, so it has to be hard final.
Okay. Yes, item 1. Yes.
Substantial question of law was framed on 13/11/2009.
Non-compliance of section 37.
36
36. Huh?
of the Assam Temporary Settlement.
These are provisions I have forgotten. Just a moment. It's- In fact, temporary settled areas tenancy act, I think I'm touching it after 8 or 10 years. Almost forgotten. No, but first I'll refresh myself with these provisions of that section 36 rent suit. What is the point you want to raise on this section 36?
Regarding lordship, after Code of Civil Procedure, specify the area of the land to which the suit relates, and where fields are numbered in the village paper, the number and area of each field, and the suits for area, the amount of the yearly rent which is payable. Where the land to which the suit relates does not form one or more field number in the village paper, the plan shall contain a sufficient description of the land and its boundary.
Yes.
Here, Lordship, in my case, Lordship, I see the plain Lordship. At page 13.
It is the next here,
Yes, page
page
30. Please
30.
First paragraph. That the entire plot of land measuring 21 figure 17 lecture under dark number census covered by PT number census, Titapur Moja, and another plot of land 2 bigger 1 kata 3 lecture under dark number census Baby Diagram in Titapur Moja. Total area under both the aforesaid parta is 23 bigger 2 kata. Stand mutated in the name of the plaintiff, and they have absolute right title over the land. They inherited the aforesaid land from their possessor in predecessor in interest, which have been specifically described in the Schedule A. So Schedule A is the land lawsuit. Then lawsuit regarding rent lawsuit. Next paragraph. That the defendant are in occupation of the entire land Schedule A and are cultivating the same as adhere under the plaintiff for last few years. The entire land are used for paddy cultivation of the different varieties. The land is very fertile and yields decent products every year. It was verbally stipulated that the defendant would deposit 1/5 paddy of each year in favor of the plaintiff. Earlier, they, however, used to deposit the share of the paddy to the plaintiff. But for last 3 years, they have defaulted to comply with the terms of verbal contract and have willfully avoided to deposit the paddy. The defendant have not deposited the legitimate share to the plaintiff from year 2003, 4, 5, and 5, 6. It is not free to mention that the paddy for the cultivable year 2006, 7 are yet to be harvested, and the plaintiff reserved their right to claim the same in due course. So their claim is a schedule land we are cultivating, and since 2003 to 2006 we have not paid their share 1/5 share lawsuit. As per section 36, they have to give entire description lawsuit. So lawsuit kindly see that there are nothing in there in the plain lawsuit, except lawsuit kindly see the page 32.
33 is a schedule land, 21 because
That is land, but there is no boundary or something like that.
that's not
And the-
required in an agricultural land.
Yearly, they have to calculate yearly. Then they have calculated as a total. Logically,
No, you see, this issue of boundaries is already well settled, not only by the Supreme Court, but also by this court, saying that even at the stage of execution, under Order 7, Rule 3, I think, it is permissible for the court to seek the boundary and then execute the decree.
But in my WS lawsuit, I have denied that lawsuit, area lawsuit, we are occupying lawsuit. That was denied by us in our WS specifically lawsuit. And lawsuit regarding Schedule B lawsuit. Can you see the B? They have calculated.
Very good. You have given them a handle to evict you from that area where you are not there.
Yes, but I am not occupying the entire land lawsuit. That is 23 bigger 2 katha lawsuit. Schedule B lawsuit total production of paddy for 3 years. They have calculated 2003 to 2006. 150 lawsuit. And then lawsuit that is divided by 3 and it comes to 90.
But come to your trial court
Yes.
judgment.
Trial court judgment lawsuit start from page 7.
Yes, you see it's
Main issue is issue number 4 and 5.
yes,
Number 4 lawsuit page 11. Here is page 11.
just a moment, there's something I'll show you to you. Page 10. The last paragraph, 2 lines.
The defendant have nothing to say.
No, page 10.
Yes, page 10.
That is the part of the order. From the appreciation of evidence on record.
Evidence on record, the defendants have accepted the plaintiff to be their landlord and also admitted they have used to give the share of paddy to Kitty's people. On the other hand, the names of sister of the plaintiff had not entered.
No, that is the only part. Here there is an admission of fact that you have accepted them as a landlord. So other issues will not arise.
Landlord I have accepted.
So then you can't help the decree. It has to be executed.
Otherwise also, lordship, then landlord I accepted, but the area of the land
No, you see, once you have accepted,
and the quantity of ready fill I have to give them, that was also not accepted, lordship, that was in my evidence, I have stated that.
no, you see, what you call, once the tenancy is accepted,
Then I say,
some form of rent has to be paid.
exactly, that is it. And I have also accepted that 2003 to 2005 I have accepted, only 5 and 6 I have, 2, 3 and 2, 4 I have accepted. Only 5 and 6 I have not paid because they have not come to collect the same, that was my evidence, lordship. That issue regarding issue number 3, lordship, and non-joiner of necessary parties.
I may be wrong, but a man who has 21 bighas of land and gives it to you for cultivation for years together, I don't think he has a necessity to go there and collect adhiya.
But that was the evidence, lordship, given by me, lordship.
Because you see, in that also page 11, come to your issue number 4.
Yes.
In the middle, he said, he has forgotten. That is,
Forgotten when he went to the defendant to collect the share of pay.
so the landlord of this nature, who does not even remember when he went last to collect.
In fact, that was a verbal agreement, lordship. No receipt has been given for payment, lordship. That was also in the evidence. Lordship.
No, but this also means that, you see, if he doesn't remember, that means it is quite possible that for 3 years you have not paid him. He is only asking for rent, which has not become time barred.
Yes, that is time, but in 2007 he has filed the suit.
Huh.
In 2004, he sent one legal notice to me, lordship, for eviction, lordship. And in fact, his evidence, lordship, PW1 clearly stated that he did not require the rent, lordship, he required the land, lordship. Not rent. That was his evidence. In cross, he has specifically stated.
Because you see, this issue number 5, the court has done wonderful. Issue number 5, last few lines. He has also calculated the yield capacity of that land. The so and so has deposed that each pura of land, 4 bighas is equal to 1 pura,
Yes,
has capacity to produce 30 to 40 man paddy in a year,
for year.
which is 1 man is 40 kg. And considering the evidence of the defendant alone, it can be said that the land has the capacity to yield a decent quantity of paddy if we decide in the affirmative. So the court has gone to that extent to find out the yielding capacity of the land.
But without any lordship.
It's your evidence. He is discussing your evidence. So I think second appeal has to be dismissed.
Lordship, in appellate judgment, that is not discussed. Lordship, can you see the appellate judgment, how 4 and 5 discussed, lordship? Page 24.
Because the only, you see, this is only a rent suit.
Yes,
So issue number 5, trial court at page 27 has dealt with that. Same thing. Yield capacity is there, therefore this issue is decided.
regarding,
Other admitted facts need not be proved, therefore I agree with the decision.
on the basis of the admission of the appellant lordship, they have decided.
It can be helped.
It is only for payment.
Yes, Mr. D, why this appeal should not be allowed?
Lordship, in page number 12 also it is clearly stated that defendants have failed to show they have offered the share of petty.
Where? You are reading where?
Page number 12.
12. Which issue?
First paragraphs in page number 12.
Huh.
The defendants have failed to show that they have offered the share of patty and delivered it from 2003 to 5. Again, it is admitted position that they have not offered rent for the year 2005 and 6 to the plaintiffs. Considering the evidence, the issue is settled. And in the
So defaulter is proved. So, Ms. Bhattacharya, we are closing it. Uh, But Mrs. P. Bhattacharya, learned counsel for the appellant, and Mrs. Todi, learned counsel for the appellants and respondents. Next para. By filing this appeal under section 100 CPC, the appellants have assailed the first appellate judgment and decree dated 27/7/2009, passed in rent appeal number 1 of 2009, passed by the learned civil judge Jorhat in rent appeal number 1 of 2009, thereby dismissing the appeal and affirming the judgment and decree dated 25/2009, passed by the learned Munsif number 1 Jorhat in rent suit number 2 of 2007. Next paragraph. This the respondents as plaintiffs had filed a rent suit for recovery of rent in respect of the plot of land described in Schedule A of the plaint. Full stop. In the plaint, it has been claimed that the entire (23 bigha 2 katha 0 lacha) land is has been given to the respondents as to the appellants on adhiya basis. How would be adhiya spelled? ADHIA. HAI. Adhi. ADHI.
HIAR.
Adhiya.
Adhyar.
No, R is tenant. So Adhiya. For paddy cultivation. And that the rent is sought to be recovered in form of 1/5 share of the respondent's plaintiff against total production of paddy from the Schedule A land, which, according to the respondents, was rupees 90,000 for the years 2003-4 TO2, 2005-6. Full stop. It has been submitted at the bar that the from the nature the claim made by the respondents plaintiffs, comma, the rents, the said rent suit is within the scope and ambit of Assam within bracket temporary settled areas bracket close Tenancy Act, 1971. Full stop. The appellants had contested the suit by filing a written statement. Full stop. The learned trial court had framed the following issues for trial, page 9, 1 to 7. Full stop. Issue number 1 relating to cause of action was answered in the affirmative. Issue number 2 is not decided. Oh, it decided, huh? So the issue number 2 with as regard the maintainability of suit was also decided in the affirmative and in favor of the respondents. Full stop. In respect of issue number 3 regarding whether the suit was issue number 3, the said issue was decided in the negative and in favor of the respondents by holding that the suit was not bad for non-joint or necessary parties. In view of the admission made by the appellant, Maniram Hazarika, M-A-N-I-R-A-M Hazarika, during his cross-examination that he used to give paddy to Shatish, K-H-A-T-I-S-H, Fukan, only and not to others. And as they said, Shitish, K-H-I-T-I-S-H, Fukan, and Jyotish, J-Y-O-T-I-S-H, Fukan, were accepted to be their landlords, full stop. Next paragraph, in respect of issue number 4, after examining the evidence on record, the London Trial Court held that the defendant, the appellant, he's the appellant or is not the appellant? This Maniram Hazarika is there. The appellant number 1 had deposed in his evidence on affidavit that they had already paid share of the respondents till 2004-2005, and they have to pay for the year 2005-2006. And in the said context, the Learned Trial Court held that when the landlord had taken a plea that he has not been offered rent, the owners would shift on the tenant to prove that he had offered rent to the offered share of paddy to the respondents from 2003 due to 2005. And accordingly, the issue was decided in the affirmative and in favor of the respondents. That the appellants had not deposited their share to the respondents from 2003 to 2006. Stop. In respect of issue number 5, the learned trial court, relying on the cross-examination of appellant number 1, to the effect that each inverted commas of pura PURA of land within bracket 4 bigha equal to 1 pura bracket closed had the capacity to produce 30 to 40 inverted commas of MUND bracket inverted comma closed paddy per year within bracket 1 MUND is equal to 40 kg bracket closed. Now it was held that the suit land had the capacity to yield a decent quantity of paddy, and according to the issue was decided in the affirmative. In respect of issue number 6, in view of the discussions on the other issues and taking note of the admission of the appellant number 1 that they had occupied 23 bigha 2 kata land, arrived at a conclusion that this was indicative of the appellants cultivating the said area of land, and that the claim by the respondents that the market value of each quintal of paddy was ₹1,000, on which there was no cross-examination, the value claimed by the respondents was accepted as ₹1,000 per quintal. And accordingly, the respondents were found entitled to decree as prayed for. Full stop. In respect of issue number 7, it was held that in view of the decision on the other issues, the suit was decreed on contest. Next paragraph. Agreed by the judgment of the learned trial court, the matter was taken up in appeal, being for rent appeal 1 of 2009, and the learned first appellate court concurred with the finding on each of the issues by independently appreciating the evidence on record, as well as on examination of the trial court judgment and all the findings on all these 7 issues. On 6 issues were affirmed, and insofar as issue number 2 is concerned, the learned first appellate court held that the said issue was unnecessarily framed. So accordingly, the judgment and decree passed by the learned trial court was affirmed. Next paragraph. This appeal against the first appellate judgment, affirming the judgment of the learned trial court, was admitted for hearing on the following 3 substantial questions of law. Order sheet by order dated 13/11/2009. Page 2, order sheet. Next paragraph. The learned counsel for the appellant, by referring to the provision of section 36 of the Assam urban, sorry, Assam temporary, within bracket temporary settled areas, bracket close, Tenancy Act 1971 has submitted that the suit was in non-compliance of the said provision. By referring to the schedule appended to the plaint, committee submitted that the four boundaries of the suit land was not described. And accordingly, it is submitted that unless a proper description of land is contained in the schedule, comma, the decree, the suit could not have been decreed. So accordingly, it is submitted that not only the judgment and decree passed by the Illinois trial court, but the first appellate the judgment and decree was also vitiated. Full stop. In this regard, it would be appropriate to refer to the provisions of section, Rule 3 of Order 7 CPC, as well as the High Court amendment in respect of Guwahati, which is same as in Calcutta. After this provision, this is High Court amendment. You write Calcutta and then Guwahati, same as Calcutta. You don't have to say Bombay. Just from the above, it would appear that the High Court amendment of Guwahati requires stating of the area according to the notation used in the record of settlement of survey. Full stop. It could not be demonstrated that the appropriate description in terms of the High Court amendment to the provisions of Rule 3 of Order 7 was not contained in the schedule appended to the plaint. Full stop. Moreover, as already mentioned herein before, there's a concurrent finding of both the trial court as well as the first appellate court that the appellants had admitted the respondents to be the landlord in respect of 23 bigha 2 katha land which tallies with the description of two plots of land contained in Schedule A of the plaint. Or the court is of the considered opinion that there was no dispute with regard to the boundaries of the suit land, and that the appellants had contested the suit with full knowledge of the boundaries. Therefore, in view of the admission made by the appellant number one in his cross-examination, in his examination, chief and cross-examination, the evidence being contrary to the stand taken in the written statement to the effect that they had been occupying how much land? Written statement, you said,
14 meter plus worship 2.
where is that?
14 bigger, 1 kata 2 lesser, and worship then
That's
worship
right.
2 bigger, 1 kata.
Just these two, she didn't write down. 14 bigger
1 kata 2 lesser,
and
worship 2 bigger, 1 kata 3 lesser.
EB করে দিব, would stand disproved, and the admission made by the said witness would be read in favor of the respondents. Full stop. Therefore, insofar as the first substantial question of law is concerned, the court is of the considered opinion that the suit was maintainable and no case has been made out by the appellants regarding non-compliance of by the respondents of the statutory provisions laid out in section 36 of the Assam within bracket temporary settled areas bracket close Tenancy Act, 1971. Full stop. There is another aspect to the issue. Full stop. It has been laid down in several judicial pronouncement by the Supreme Court of India as well as of this court that in case there is any mismatch of the boundaries, even at an executing stage, they said the boundaries could be the correct boundaries can be taken on record. So therefore, mere absence of boundary or misdescription of boundary would not scuttle the the decree passed in the suit. Next paragraph. In respect of the substantial question of law number 2, it could not be demonstrated from the LCR that the finding regarding quantification of the rent was only on the basis of surmises and conjectures. The learned trial court as well as the learned first appellate court had returned a concurrent finding to the effect that the value of paddy quantified at rupees 1,000 per quintal per month or quintal, 1,000 per month or quintal
per quintal.
Per quintal, per quintal.
Page 33.
Was admitted in view of the non-cross examination of the respondent's witness on such valuation. Therefore, as the respondents had given the quantification of value of paddy per quintal at rupees 1,000 in Schedule B of the plaint, the court is unable to accept on the basis of on the basis of evidence available on record, pleadings and evidence available on record, that the quantification of rent due was merely on the basis of conjectures and surmises. Full stop. If moreover, if quantification of rent is on the basis of agricultural produce, the product by its nature has a fluctuating market value, which is dependent on various factors. Full stop. The appellants had not led any evidence to show that although the although there was yield of 30 to 40 months MUND of paddy every year from the suit land, its quality would not fetch the value given by the respondents in the schedule of the plaint, Schedule B of the plaint. Moreover, as the witness of the appellants had admitted the yield capacity of the and had disclosed the yield capacity of the land, suit land, the quantification of rent does not merit interference in this second appeal when there is a concurrent finding of fact. Full stop. The rate of paddy is a pure question of fact, and it is in the considered opinion of the court, unless perversity is shown, the quantification of paddy cannot become a substantial question of law. First of therefore, the court is of the considered opinion that no substantial question, that the second substantial question of law, in fact, cannot be regarded as a substantial question of law, being a pure question of fact. Nonetheless, the said question is decided against the appellant and in favor of the respondents. First of, in respect of substantial question of law number 3 is concerned, strike it out. In view of the finding returned in respect of the substantive question of law number 1, comma, it is held that the decision of the learned trial court as affirmed by the learned first appellate court does not warrant interference, as it could not be demonstrated that relevant law and facts were not taken into consideration while deciding the suit and the first appeal. Full stop. Next para. According to this appeal fails and the same is dismissed. Full stop. It is dismissed with usual cost. Next para. Let the LCR be returned. Next para, let a decree be prepared. First decree be prepared, then LCR return.
Item 2.
Yes, Mr. Sharma.
Has been preferred against the extent passed by the Laman or the
You are the plaintiff for the defendant. You are the plaintiff for the defendant. No, you are the plaintiff for the defendant. You are the plaintiff. Defendant. The suit was decreed against you. Appeal also dismissed. Okay. Oh, okay. Reversal. Decree of reversal. Okay.
According to plaintiff respondent, appellant has taken a loan with 40,000 from in the year 2003 by giving a hand on the promise to return. It did not return. That is why he filed a suit for re-election. But defendant he was there. He took only rupees 100 or 1,400 in 2019 by taking a signature on the bank level, and subsequently he has rupees 1,000 for the because this case. And that is why he is eligible to pay the rupees 1,000 after the court. No, actually also the plaintiff, we have one actually says house in the court campus as the selling team. In that man of that capacity after 40 years, 20 years ago, it is not possible to enter give a loan of rupees 40,000. That's so also unbelievable. That is
Each stall owner cannot give a loan of 40,000.
loan of 40,000, no capacity. Because here one actually
No, I don't know. I was just smiling because I seen in Guwahati, there's a tea shop called MBA Chaiwala. And somebody told me that after doing his MBA, he deemed it appropriate to start a tea shop. I don't know, because I have not been fortunate enough like our Prime Minister to sell tea. But I don't find that people who are
that's why I'm telling the fact. And the tenant he was there.
you know something. There's a person who is a Jain from Jain community. He's one of the his assets is calculated at about between 30 to 40 crore. No, sorry, 70 crore. He was caught by the income tax for purchasing a property of 30 crore. And then it was found out that he is a beggar by profession. You see the net, you will come to know. Richest beggar in India. Whatever name, beggar, richest beggar, or whatever permutation combination you want to make it. And this man name will come up. He has 18,000 beggars under him in Bombay. So when I have spare time, I read those funny things. No, because you see in the plaint, I have read it in the plaint. It plaints he started that he is not a money lender. And when you are making a statement that he is a tea vendor, it belies the statement that he was a professional money lender.
Also doing the interest of money.
No, Mr. Sharma, you see, knowing your status as a earlier as a good judicial officer, then now as a as a successful, very successful lawyer, not successful, very successful lawyer. You see, if two people approach you for some money, will it make you a professional money lender? Many people who are at distress may approach one friend or the other, or someone he knows for some money, and he lends it. Supposing you lend it not only to one person, but two persons, will it make you a money lender?
When I take the fee of the money and I know interest with them, then the issue should have been claimed on the permit.
No, you see your denial. You come to that your written statement. The plaintiff's where did he say that he is not a money lender? Please find out that. Para 1 of the plaint.
Interest with them.
No, para 1 of the plaint first. He is not a professional money lender.
There are one of the claims that the defendants being in need of money, approached the plaintiff to advance loan of rupees 40,000. The plaintiff had then the relationship with the defendant, and though the plaintiff is not a money lender by profession, he had agreed to lend the money to the defendant. They denied it. But in my written statement, I had disputed it. My written statement, my page 37, for the petition, there are 4, madam.
Page.
Page 37, there are 4. That the suit is barred by the Money Laundering Act, and the plaintiff as professional money lender has no legal right to file the suit against the defendant without the legal verifications under the Assam Money Laundering Act. As such, this court has no duty to.
So that is a positive assertion. Then your burden of proof is on you. Because you see,
When the plaintiff asserted one thing in a claim and defendant denied it, then issue arises. The trial court has not.
no. That cannot be an issue. You see, let us say that somebody writes in the plaint that I am the son of so and so. I have 3 siblings who have all inherited property from my father, and somebody denies it. Will it be an issue? Whether parentage can be an issue?
Actually, when the issue arises, when the plaintiff asserted things in the claim and defendant denied it, then issue arises.
No, I understand, but you see, we are in second appeal. You did not.
The trial court has not raised the issue.
No, that is okay. But you proceeded with the suit. Did you lead any evidence?
So I have got the evidence here.
Have you proved? No. You, Mr. Sharma, that is unacceptable. Very simply, because if one says that I am not a professional money lender, that is something a statement which is in negative. I am not known of any theory where negative is required to be proved. I give a statement that the sun does not rise from the west. It's a statement in the plaint. Now you say, please prove it.
I have a decided case law, my lord. Without the money laundering license, he cannot.
No, that is okay. But please show us that he is a money lender. Did you give any evidence that he is a money lender? Did you?
Yes, I have given you. My defendant said that he is a money lender. But
No.
has not claimed the issue.
Will it be sufficient? Now let us say that I pinpointed a lawyer, this lawyer X. He's a scrupulous lawyer, unscrupulous lawyer. Let us say I make that allegation. I pointed to the wall and say that there is a lawyer here, and he's a unscrupulous lawyer.
The issue is not clear, my lord. Then how things should be decided?
I'm asking you because you see, you have been there. You have been to this side. You have sufficiently for a long time. You have been in this side. That is why I'm asking you. You have experience of both sides,
That is the.
being here and there. So I'm asking you, can a negative? Who will prove the negative?
Money laundering act is clear, my lord.
That I know, provisions have, this is something which I am aware. You did not cite that provision of Money Lending Act. But you see, who is, how will you prove the fact that he's a money lender? What is the evidence which is acceptable to the court?
Let's take that, the money lender.
Okay, very good. Now my question to you, Mr. Sharma. My question to you. X is in a, this is a example which I give daily. I'm once again repeating it. If you have heard it, you will excuse me. You see, a man A files a suit that I am the President of India. And he comes into the dock. His exhibit number 1 is his own affidavit that I am the President of India. Then he comes to court, stands on the dock and says that I am the President of India. So if I accept your statement, then only by saying that I am a President of India, I become the President. No, why? What is the difference? Mr. Sharma, what is the difference? What is the difference? In these two examples, what is the difference?
He has one actually says house minor. He's selling the tea and therefore he's lending money to other some character.
Inconsistent statement you are making, Mr. Sharma. We are in second appeal. Don't make inconsistent statement. No. You started by saying that he is a tea shop and he can't lend money. That was your first statement. Don't recile. You see, this is a court of record. And we have your video also for it. So don't worry. You see, I have framed it. But that is why I'm asking you a question. Okay, then argue. I want to ask you a question. Argue that.
He denied that he's not the money lender. I say that, so no issue has been come on that one.
Okay, next point.
The issue has.
I have understood that. Next point.
Actions are not provided, actually.
Third.
I'm looking at the evidence of the money.
No, don't read that. You just show me only one part. Don't read the entire evidence. We don't have time. You read the only that relevant part.
One evidence. মই বাদিক চিনি পাওঁ বাদিৰ দোকানত মোৰ অহা যোৱা মই বাদিক এমনকি ইমান তাৰিখে 40,000 টকা ধাৰ লোৱা নাই 100 টকাৰ ৰেভিনিউ টিকেটৰ ওপৰত থকা ছবিটো মোৰ কিন্তু ওপৰৰ ছবিটো মোৰ নহয় বাদিয়ে মোক স্বীকৃতি দিছিল নে নাই মোৰ মনত নাই 1990 চনত বাদিৰ পৰা মই 1000 টকা লৈছিলো ধাৰ লৈছিলো তাৰ সত্য নহয় যে বাদিৰ পৰা বাদিৰ পৰা মই হেণ্ডলুম দি 40,000 টকা লৈছিলো বাদিৰ পৰা 100 টকা 1000 টকা লৈছিলো 40,000 টকা নহয় and the under my loan it only one has started in the cross it is one with plenty the Borpeta court or compounder আজি মই 25-30 বছৰ ধৰি চাহৰ দোকান দি আছো বাদি বিবাদী হেমন্ত দাস এই আদালতৰ জাৰিকাৰক এই সময়ত হেমন্ত দাস মোৰ বন্ধু আছিল আজি প্ৰায় 1.5 বছৰৰ পৰা আমাৰ বন্ধুত্ব চিনি গৈছে টকা পইচা লেনদেন 6/1/2003 তাৰিখে মোৰ দোকানত হৈছিল 6/1/2003 তাৰিখে মোৰ মনত নাই চাহৰ দোকানৰ বাহিৰে সৰু সুৰা ঠিকা কাম কৰোঁ মই ইনকাম টেক্স দিওঁ ইনকাম টেক্স ষ্টেটমেণ্ট মই দাখিল কৰা নাই এতিয়া টকাৰ উল্লেখ কৰা নাই হেণ্ডলুম খান এজন মহৰীয়া লিখিছিল তেওঁৰ নাম বেণুধৰ দাস মই মহৰীজনক হেণ্ডলুমখন লিখিবলৈ কৈছিলো মোৰ সাক্ষী গোবিন্দ দেউৰীয়ে হেণ্ডলুমত চহী কৰা নাই মই 100 টকীয়া নোটত 100 টকীয়া নোট 4টা বাদিক দিছিলো মই বিবাদীক টকা ধাৰে দিয়া সময়ত তেওঁ আৰু আদালতৰ বিবাদী আদালতৰ পিয়ন কাম কৰিছিল বিবাদীক ধাৰে দিয়া টকা দিব পাৰি বুলি কৈছিল ৰেভিনিউ কাম পাৰোঁ কাগজ বিবাদী হেমন্তই নিজে আনিছিল হেণ্ডলুম লিখি এইবিলাক টকা এইবিলাক কথা জানে মোৰ সাক্ষী গোবিন্দ দেউৰীয়ে মোৰ দোকানত কাম কৰি থাকে কেতিয়াবা বহেও কিন্তু সত্য নহয় যে বিবাদীয়ে এখন সম্পাদন কৰি মোৰ পৰা 40,000 ধাৰ লোৱা নাই সত্য নহয় যে 1990 চনত মোৰ পৰা বেংক কাগজত চহী লৈছিল মাত্ৰ 1000 টকা ধাৰ লৈছিল। পিছত উক্ত কাগজখনত মই 40,000 টকা এডমিট কৰিছিলো। সত্য নহয় যে মই নিজে ৰেভিনিউ ষ্টাম্প আৰু কাগজ লগাইছিলো। Other evidence, cross examination. যে আদালতৰ মহৰীকান কৰোঁ মই অধিবক্তাৰ মহৰী অধিবক্তাৰ তালুকদাৰৰ কাগজ মহৰীকান কৰোঁ। মই হেণ্ডলুক কাম কৰোঁ। বাদী বিবাদী মই চিনি পাওঁ। প্ৰদৰ্শক এখন লিখাৰ কাৰণে বাদীয়ে মোক তেওঁৰ দোকানে মাতি আনিছিল। মোক মাতি নিয়াৰ পিছত মই প্ৰদৰ্শক কাগজখন টেবুলত পৰি আছিল। মই গৈ মাত্ৰ লিখিছিলোঁ। মই প্ৰদৰ্শক এখন লিখাৰ সময়ত বাদী বিবাদী আৰু এজন শকত মানুহ আছিল। মই চাহৰ দোকানৰ টেবুলত প্ৰদৰ্শক এখন লিখিছোঁ। বাদী কাউণ্টাৰৰ ওচৰত টেবুলত বহি প্ৰদৰ্শক এখন লিখিছোঁ। মোৰ আগত টকা পইচা আদান প্ৰদান হোৱা নাই। বিবাদীয়ে মোৰ আগত প্ৰদৰ্শক কাৰ্ডখন চহী কৰা নাই। সত্য নহয় যে প্ৰদৰ্শক লিখাৰ আগতে তাক বিবাদী statement right amount. Now, the preliminary cross examination, বাদী দোকানৰ মই প্ৰায় 1000 কৰোঁ। আজি প্ৰায় 7-8 বছৰ ধৰি পোৱা দৰৱ আপেলি চাৰিজনী এখন বাদীয়ে মোৰ লগত ঠিকা কাম নকৰে। He has stated that he has business project with the utility. বাদীয়ে বিবাদী 40,000 টকা দিয়ে দেখিছোঁ, কিন্তু মই হেণ্ডলুকৰ সাক্ষী নহয়। Because writer has not stated that he was present at the time of writing the handbook, but he has stated that he was not present in the writing of the handbook. But so the parents of is not there. How we can see? He is not present. বিবাদীয়ে বাদী টকা দিছিল, কিন্তু বাদীয়ে বিবাদী টকা 40,000 দিছিল মই নাজানো। বাদীৰ চাহৰ দোকানত এটা ৰুম আছে। বাদীয়ে বিবাদী টকা দিওঁতে মই কেছ কাউণ্টাৰত বহি আছিলোঁ। টকা পইচা আদান প্ৰদান হোৱাৰ ঠাইত মই উপস্থিত নাছিলোঁ। বিবাদীয়ে মোৰ পৰা টকা মোৰ চিনা জনা আছে, কিন্তু কথা বতৰা নাই। সত্য নহয় যে মই মিছা সাক্ষী দিছোঁ। সত্য নহয় যে মই বাদীৰ কাছে মিছা সাক্ষী দিছোঁ। গতিকে he has two witnesses. None of the witnesses have supported that he has not the payment. That's what it matters. Now I have the evidence.
Mr. Sharma, are you not wasting the time of the court? In a substantial question of law, you started your argument on the point that he is a moneylender. Now you are reading the evidence as if I am appreciating the evidence. I will go into the evidence, reappreciate the evidence on record, and then give a verdict. Are you not wasting the time of the court?
No, my submission will be carefully remanded for getting an issue on that point and to decide it. Because when I have taken a decision.
You have read the evidence. You have read the evidence. In your evidence, where you have questioned that he is a moneylender.
Because it is specifically barred by law, when without a valid license, the moneylending this cannot be done. So the case from our own side. It is my daughter, Russian TV shows, without the court. The Assam moneylending no proof of the proof for the recovery of the loan advanced by the moneylender to proceed to the civil court if the moneylender does not have a valid registration certificate to carry on the basis of moneylending.
Is that Eastern Tea? That is a case of Eastern Tea. What is the name of the parties? Eastern Tea. Ask me that judgment. Ask me that judgment.
The act is also clear, the section 7, Section 7B Act The suit proceed without registration charge, no suit for recovery of the loan advanced by a money lender shall proceed in the civil court until the court is satisfied that the whole said there is registration certificate or that he is not there, it is not required to have a registration certificate by reason of the fact that he does not carry on the business of the money lending.
Okay. That's all.
So my submission, my lord, the case will be remanded for taking a charge on the point, on the subject of question of law. And we decide all the issues that are faced by
Okay.
reporting evidence in the second. Moreover, here the Lagos, Munshi, does not believe that the registration of the hand on minor. According to him, it is not a hand law, it is minor, issue number 5 minor. It is not a hand law, it is a bone minor. So it is.
It is a,
It is a bone minor.
what according to you is a hand note? What is the definition of hand note?
It is by the issue number 5 minor.
What according to you, I am asking you a question. What according to you is the definition of hand note?
I love the in the case of the hand of the just maybe they were on the revenue stand. The revenue stand in the paper, there is the one has to sign.
No, there must be some definition. What is the definition?
Issue number 4.
No. First of all, you see, I don't know what is a hand note. Please tell me what is the definition?
Document written by person for giving loan to the another person by obtaining signature the borrower on a revenue. But here it is said that it is a board, it is written on stamp paper.
You have currency notes in your pocket. You have currency notes in your pocket. You definitely will have some denomination note. You can just bring out your denomination note and any note, any currency note.
But on the one, the issue number 1,
You bring out any currency note. I'll tell you what is the definition of a hand note. Take out your currency note. From your pocket, take out a currency note. Take out. Unless you take out, I won't be able to say anything. You give him a note, money. Show him some money.
the case what the court has decided, I want to.
No, if you see, I have asked you a question of money. In the currency note, you will see Mr. Sharma has given. In this currency note, you will see there's written, I undertake to pay to the holder a sum of rupees 500. That is a hand note. It is signed by the governor of the Reserve Bank of India. You please return this note again to Mr. Sharma. So that is a hand note. Thank you, Mr. Sharma.
Agreed one, as the initial of the claim, is registered, revenue stamp of 80% was achieved on it. As per amendment of the Indian Stamp Act, 1899, the duty of 20% revenue stamp was.
Just a moment, just a moment. No, Mr. Bhuya was smiling. You see, there is a difference. If you have a 1 rupee note, take out that note. It is signed by the Secretary Ministry of Government of India, Ministry of Finance. So that means that is the only legal tender. And earlier 1 rupee coin was issued only by the Government of India. So in India, only 1 rupee note is now a legal tender. If you go with that 500 rupee note to a bank and say that ask the governor to give me 500 rupees, he'll give you one rupee coin 500 in exchange. So that is the difference between a 1 rupee note and any other currency note above rupees 1. They are not signed by the ministry. That is the uniqueness.
And something on the basis of the issue decided by the Father Child Board, the Munshi, that it is not properly stamped, so it is not admissible, and it is not admissible, that is why it is not properly stamped. According to him. যদি এর নাকি দ্বিতীয়টা তৃতীয়টা তাদের someone annexed to rupee one and in POB, the handbook not sufficiently stamped. It is decided negative. It is over the right. So handbook according to January not a mission one, or not fixing the over not one, because they remain some. So when the handbook is not being sold, that is why he likes to see that. But Lana time, appearance code is out, Lana appearance code when the budget, holding the epidemic.
দাসী এইটো দিয়ক ইণ্ডিয়ান ষ্টেম্প এক্ট ষ্টেম্প এছ Okay. That's all.
Something that is part by section 7 of the money, so the government and home, and learn from more of the handnotation of emission as per Dana Muslim. So the amount cannot be fixed. And thirdly, as per evidence also, there is no witness of at the time of paying money to the defendant, but it's money. So the case is not so. So Dana Muslim likely to fix it. And the that could be heard without discussing those aspects of the money. So that is.
Mr. K. Sharma and counsel for the appellant. None of is on call for the respondent. Next paragraph. This appeal under section 100 CVC is by the respondent defendant who is aggrieved by the first appellate judgment and decree dated 13/5/2009 passed by the learned civil judge Borpeta, by which the suit of the respondent plaintiff was decreed by allowing the appeal and setting aside the judgment and decree dated 19/8/2008 passed by the learned Musif number 1 Barbeta in money suit number 22 of 2008. Next paragraph. in brief, comma, the pleaded case of the respondent plaintiff in the plaint is that the appellant, being in need of money, had taken a loan of rupees 40,000 from the respondent by executing a hand note dated 6/1/2003 with a promise to pay the said amount on demand along with interest. And it was asserted that the respondent was not a money lender, and that as the appellant had to failed to repay the loan, even after demand, comma, the respondent served advocate's notice on the appellant on 8/7/2005. Which was served on 13/7/2005. But and thereafter the suit was filed. Full stop. The appellant contested the suit by filing written statement by claiming that the respondent was a money lender and the suit was barred by limitation as well as under the provisions of Assam Money Lenders Act. Local X of the word. Local X of the word and local X. Local X. Okay, M out of them. Take it aside. Hmm. Uh, 1934. As the respondent was a professional moneylender doing business without valid registration. First of all, it was also claimed that the handle was not sufficiently stamped. And the execution of the hand note was also denied by claiming that the signatures were taken on a blank piece of paper. Containing revenue stamp, which was signed on good faith. Stop. The learned trial court framed the following issues for trial. Page 23-24. Right. Seven issues. Next, the respondent plaintiff had examined 3 witnesses, including himself. As PW1, Benudhar Das as PW2, and Rabin PRABIN Deuri DEURI as PW3. And exhibited the hand note within bracket exhibit 1, advocate's notice within bracket exhibit 2, and postal receipt within bracket exhibit 3. Full stop. The appellant examined himself as DW1 and did not exhibit any documentary evidence Full stop. I'm sorry, the issues, 7 issues and 1 additional issue. Huh? That is also at page 24. Issues number 1, 2, and 3 regarding cause of action, maintainability of the suit, and whether the suit was barred by limitation were all decided. In favor of the respondent appellant, the respondent plaintiff. In respect of issue number 5, the London trial court had referred to the evidence of the witnesses and found the evidence of the PWDs to be trustworthy and returned a finding that the appellant had taken a loan from the respondent on 6/1/2003 by executing a hand note. And accordingly, the issue was decided in the affirmative and against the appellant. In respect of additional issue number 1A, it was held that the hand note was sufficiently stamped. No, was not sufficiently stamped, as the hand note contained revenue stamp of 80 paisa, whereas the appropriate revenue payable was ₹1, and accordingly it was held that the hand note was not sufficiently stamped. First of all, in view of the finding returned in respect of additional issue number 1 within bracket A, in respect of issue number 4, it was held that the respondent was not entitled to recover money from the appellant. And accordingly, in respect of issue numbers 6 and 7, it was held that the respondent plaintiff was not entitled to any relief, and the suit was dismissed. Next paragraph. Appeal was preferred against the judgment and decree passed in the Bharat London trial court. Full stop. the London First Appellate Court formulated the following point of point for decision. As to whether the impugned judgment and decree was passed erroneously, had been passed erroneously without properly appreciating the evidence on record, and is not legally sustainable. What's wrong? Next paragraph. Insofar as the issue number 1, 2, and 3 are concerned, the finding of the Learned Trial Court was affirmed. Full stop. The remaining issues were taken up together for adjudication. Full stop. In respect of the additional issue number 1 within bracket A, the Learned First Appellate Court had referred to the provisions of section 36 of the Stamp Act, 1899. Had held that the Learned Trial Court did not take into account the said provision of law The provisions of section 35 and 36 of the Stamp Act, 1899 is reproduced below. I said, don't write it here. Just say, don't write here. Accordingly, as the court, as the London Appellate Court found that the document was, that the Exhibit 1 was marked in evidence without raising issue on the maintainability, and also appreciating the decision of the Learned Trial Court on issue number 5, wherein the wherein the finding was written that the appellant had taken a loan on 6/1/2003 by executing a hand note, held that the learned trial court had committed grave error of law by ignoring the provisions of section 36 of the Stamp Act. And accordingly, the issues are decided against the appellant and in favor of the respondent plaintiff by holding that the once a document, once exhibit one was admitted without any objection as to admissibility, comma, the no objection as to admissibility could have been taken. So in this regard, reliance was also placed on the provisions of Order 13 Rule 3 CPC. And it was held that the provisions of Order 13 Rule C 3 CPC must yield via ELD to section 36 of the Stamp Act. And accordingly, the decision of the learned trial court on issue numbers 1 within bracket additional issue number 1A, comma, issue numbers 4, 6, and 7 was reversed, and the respondent plaintiff was found entitled to decree as paid for. Next, asserting the impugned judgment and decree passed by the learned first appellate court, comma, the learned counsel for the appellant had submitted that the no, now you're right. This appeal was admitted for hearing on the basis of the following substantial questions of law as framed by this court by order dated 2/12/2009, order sheet page 3. Like next paragraph. In support of the appeal, the learned counsel for the appellant has submitted that the learned trial court committed grave error in proceeding the suit without claiming any issue as to whether or not the respondent was a moneylender. So it is submitted that the provisions of Assam Moneylenders Act, 1934, barred adjudication of a suit unless the moneylender had a valid registration under the said act. It is also submitted that as the learned trial court had arrived at a finding of fact that the handout was not sufficiently stamped, comma, the learned first appellate court committed grave error in accepting the said handout and passing a decree against the appellant. So accordingly, it is submitted that there was a fit and proper case for remanding the matter back to the learned trial court for fresh adjudication on the all the issues, as well as to frame an additional issue of whether the respondent was a moneylender. Next, in support of his submissions, it is also submitted that in the written statement, a specific averment was made that the respondent plaintiff was a moneylender. Next para. There was one more submission, Mr. Sharma. You had made 4 submissions. What is one more submission I have left out?
There is no evidence that this is for the one.
Oh, yes. It is also submitted that the plaintiff witnesses number 2 and 3 did not support the evidence of the respondent plaintiff about loan being taken, as they were not the witnesses to the actual handing over of the money. Good stop. Next para. Consider the submissions of the learned counsel for the appellant, as well as consider the materials available in the LCR. Full stop. It would next para. In respect of the decisions of the learned first appellate court on issue numbers 1A, and additional issue number 1A and issue numbers 4, 6, and 7. It would be relevant to quote the provisions of section 35 and 36 of the Stamp Act, 1899. Full stop. Well, the provisions of section 35 of the Stamp Act made instruments not duly stamped and inadmissible in evidence. But the provisions of section 36 thereof provided an exception to the provision of section 35 by providing that where an instrument has been admitted in evidence, such admission shall not, except as provided in section 61, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. Owing to the reference to section 61 in the provisions of section 36 of the Stamp Act, 1899, it would also be appropriate to quote the provisions of section 61 of the said Act. Full stop. From the quote here, yes, on a perusal of the provisions of section 61 of the Stamp Act, as the learned first appellate court had admitted in evidence had made an order admitting admitting exhibit one. No, strike that out. First of all, in this case, the learned trial court had admitted in evidence exhibit one. Full stop. Although exhibit one was discarded by holding that the document was not sufficiently stamped, the first appellate court again admitted the said document in evidence by taking recourse to section 36 of the said act. Full stop. Therefore, in respect of the said finding, the provision of section 61 of the Stamp Act provided for revision as a remedy, and therefore, in respect of the said finding, a second appeal would not be maintainable in law. Full stop. In view of the prescriptions contained in section 61 of the Stamp Act, this court would have no jurisdiction to reverse the finding of fact as the issue has not been taken up. It's in the court's own motion, nor the question is being raised on an application made by the collector. I will continue at 2. Yes, you wanted to say something? Yes.
Engage the council AR share. He was earlier joined with our chamber, but now he's baptizing a permanent group lead. No leave also with us lordship. My learned friend said opposite party, one already expired. I suggest lordship that
Let me take up the brief, otherwise I'll not be able to follow you.
Whether it's the abatement lordship.
No, that's okay, but abatement I can't, you see, this is, when I'm rising, this is not the appropriate stage to entertain a plea of, so when I resume, you make a prayer.
Mr. A.S. have engaged our senior. He was initially with my seniors lordship, but now he permanently practicing in Dhubri court lordship. We have tried to contact, but no response yet from him, and no brief with in our chamber lordship. I am praying before lordship. Let the matter, the notice may be issued to the person concerned. to registry of the same.
No, who has died?
As per informed person of the opposite party lordship, appellant died.
We informed the appellant, Larat Council Lordship. That is, abatement Lordship, petitioner, sorry.
When did he die?
3/9/2022.
3/9/22. That has not never been brought on record. Did you inform the court earlier?
We will file a RTI.
Uh, Okay, Mr. F.U. Barbier and counsel for the appellant is present. Miss
Is Dija,
D.
Jaka.
Decca.
Not for the appellant, on behalf of my senior may sub.
Oh, acha, on behalf of, on behalf of the counsel for the appellant is present. Miss
Dija,
D. Decca, appearing on behalf of,
respondent number 1.
you are the CGC.
On course.
You are appearing for whom?
I'm a respondent number 1 or NEF railway.
Yes.
Are you a standing counsel for NF Railway?
Yes.
You are a standing counsel for NF Railway. You know, for whom you are appearing then? Who is the counsel on record?
PN Gogoi.
BN Kogoi, okay. On behalf of Mr. BN Kogoi, standing counsel for NF Railway is present and has submitted a copy of letter dated 29/4/2023 furnished by the PIO, Office of Joint Director of Health Services, Kokrajhar, that the appellant has expired. And the date of death as per the as per the record is 3/9/2022. Full stop. The learned counsel appearing on behalf of the learned counsel for the appellant shall take note of the same as I said submission and do the needful. Just a copy of the communication dated 29/4/2023 produced by the learned counsel on behalf of the standing counsel of NF Railways kept as a part of record.
Of this return, air chef engaged our senior and not being provided. He is practicing in Dhubri.
No, you see, for that I can't do anything.
I submitting before lordship. Notice to go to the appellant concern lordship to registry.
No, but when she's, you see, she is saying that the appellant has expired.
Expired.
If I have to send notice to them,
Then,
to the deceased person, you'll have to wait for, I think, I'm 56 now, 44 years more. I will personally go and deliver. Don't worry, we'll take note of that. You just renew this prayer when I'm superannuating. When I'll be demitting office, just remember, remind me, I will do that. But it is 44 years down the lane.
Problem is not wait to the hospital.
No, I understand you'll have to make copies or do anything, but I can't issue do anything. Yes, you'll have to put button up your coat first. Right. List after vacation.
I think you got to item number 10 minor. Taking up any of the date minor. Yeah, some personal difficult thing.
Then.
Okay, but then it goes after vacation. I'm not fixing a date right now, because after vacation, it will be a very difficult task to maintain, to manage the board. Both sides are represented on the joint prayer made for adjournment. Prayer is allowed just after ensuing vacation. Uh, So in respect of that first issue, subsequent question of law number 1. uh, uh, in support of his contention, the learned counsel for the appellant has placed reliance on the case of Ramdeo, RAMDEO, Ranglal, RANGLAL, within bracket Messrs. M. Obligas versus Jain Hardware Stores and others. That no suit for recovery of loan advanced by a moneylender can be proceeded in a civil court. Full stop. Uh, the said case is distinguishable on facts because from the said judgment, it appears that the statement made by the petitioner therein in paras 1, 2, 3, and 4 of the company petition clearly spelled out that the petitioner firm had been lending money to the respondent company regularly for the purpose of staff payment, labor payment, etc. Full stop. In this case, there is no such admission that the respondent was habitually lending money to the appellant. So in this context, it may be appropriate to, it would be appropriate to refer to clause 1 of section 2 of the Assam Money Lenders Act, which means a person who, in the regular course of business, advances a loan as defined in the said act Full stop. Therefore, comma, casual loan by an acquaintance to the other would not fall within the meaning of section 2 within bracket 1 of the Assam Money Lenders Act. This. So, in view of above, comma, both the substantial questions of law are decided in the question of law is answered in the negative and against the appellant by holding that as the as the respondent, as the appellant could not show that the respondent was a habitual money lender and that the loan was granted in course of his regular business of providing loan, comma, or advancing a casual loan. There's no requirement to possess a registration certificate for as a certificate as a money lender. Full stop. It may be mentioned that it is not disputed that at one point of time, the relationship between the appellant and the respondent was cordial. Full stop. The respondent was is stated to be a tea shop, tea shop, tea when the tea stall owner. And the appellant the appellant was a Jari Karak. He was a Jari Karak in the same court. Stop. Next para. This you'll add in the first point. The next para. In the plaint, the respondent plaintiff has stated that he was not a money lender. Full stop. The said contention of the respondent was denied by the appellant in the written statement, and it was asserted that he was a moneylender. Full stop. In the considered opinion of the court, comma, it's not a negative which can be a negative statement. It cannot be proved. However, when the appellant has asserted that the respondent was a moneylender, comma, both the burden as well as the onus shifted on the appellant to prove that that the respondent was a moneylender. Therefore, as it was the plea of the appellant that the respondent was a moneylender, the appellant having failed to prove the same, the decision of the learned trial court holding the respondent liable to entitled to a decree as prayed for, is not found to be vitiated either in law or on facts. After this decision on this citation, and then next paragraph. In respect of the substantial question of law number 2, comma, in view of the finding, observations and observations of this court on substantial question of law number 2, comma, the court is inclined to hold that the provisions of section 36 of the Stamp Act, comma, 1899 would have the overriding effect over the prescription under section 35 of the Stamp Act. And accordingly, the decision of the learned First Appellate Court negating the rejection of admissibility of Exhibit 1 is found to be on a strong legal foundation. And accordingly, the said finding is affirmed by holding that section 36 of the of the Stamp Act, 1899 would debar the court from questioning the admissibility of the said admissibility of the Exhibit 1 in evidence. Moreover, as provided in section 61 of the Stamp Act, has its own consequences. And is a self-contained code in itself as regards sufficiency of stamps, comma, no substantial question of law would arise for determination as regards sufficiency of stamps on exhibit 1. Just accordingly, next resultantly, comma. The court does not find any reason to interfere with the judgment and decree passed by the learned first appellate court, by which suit was decreed. The finding of the learned first appellate court stands affirmed. Full stop. The dismissal of the suit by the learned trial court is found to have been rightly interfered with by the first appellate court. Full stop. Next para. Appeal stands dismissed. With cost. Next para. Let the decree be prepared and the LCR be adjourned.
Supplementary item 15, top of the list.
No, it's okay. I have absolutely no grievance with that. Yesterday, I had asked your instructing counsel to read the relevant paragraph so that today you are free from that burden. Unless you really have to.
Yesterday, my friend told me that Lordship asked him to read issue number 4 and 5. And basically, those are the issues. Another issue was, my lord, while remanding the matter, another issue was whether he permissive occupier or not, that issue was, my lord, decided.
Permissive occupier. Something I missed out.
So,
Something I missed out.
may I just take to my lord to the appellate judgment. Page 38, my lord. For the, you know, after the judgment was delivered, by the trial court, this was the first appellate court decided the matter. Then when the matter was remanded, so lordship kindly page 41, the issues were noted down, you know. Then there are counter. Page 43, page 42, I have heard the learned counsel for both the sides. Page 42, to advance the argument, the learned counsel for the appellant relied upon the judgment of the Honorable Supreme Court in Ramdas versus Sani Muhammad, and other reported in 1998, 9 the learned counsel repeated also relied upon a judgment. Part where the Himachal Pradesh High Court, the learned counsel for the respondent entity has submitted the respondent into Raman process. Additionally, additional evidence the respondent made correction to the core boundaries of the set plane, because earlier university stated in the evidence. After considering the argument for the parties after going through the material available with the case report, I found that the entire suit of the respondent revolves around the question as to whether the appellant are permissible. So that was not the actual question. The actual question was whether it will not be sale.
Because you see that would not be correct, but that is why I perhaps it not occur to me. This is something I did not read, but now have you read? If you have read it, if I can take you to this.
Just so only one thing. Now, my lord, your lordship will kindly see. I do not know. Page 44.
Yes,
My lord will kindly see this, bring the questions, if it is allowed, the judgment and degree passed by the Learned Munsif is set aside.
Hmm.
My lord, in one hand, it is set aside. Then my lord is say, Learned Trial Court shall frame an issue as here is our observed. Thereafter, the Learned Trial Court shall answer the aforesaid issue, elevate after affording opportunity to the party to adduce evidence, if they desire and forward the case before to the court. But in my humble submission, but it was a remand under order will not.
no, even for remand, I think it will not be bad to set aside the order.
I'm just.
Ah.
No, my lord.
Because you see, supposing this has happened to this had happened to I was confronted with this question when I was a absolutely newly appointed judge. Question arose for determination was that there is a full bench judgment of this court, and out of the authors, either one or two of the honorable judges were in the sitting judges of the Supreme Court. Full bench judgment of this court, authored by the quorum of which either one or two of the honorable judges are there in the Supreme Court, sitting judges. And the matter was remanded back to this court to be decided by a division bench. So 3 judges bench, and now the matter is being reheard by a 2-judge bench. And the judgment was not set aside. Now the question is, you see, when you read Pranay, this Pranay Sethi, it's a constitutional bench judgment which says that the order of precedence has to be followed. Stare decisis has been explained. And now the remand is that the 2-judge bench will decide. Now, the question was whether the division bench, where I was one of the member, could have disregarded the full bench decision of this court. That was the question, and it was a very difficult question. And we found out an answer, and we decided the matter. But it is in that context that if you ask my view, I don't know whether I'm right or wrong, but my view is that if you are remanding a matter back, then that order has to be set aside. Otherwise, that finding remains. And that finding will, because I was confronted with that question, I know how haunting it is. You have a finding of a recorded by a larger bench, and I have to redecide it. You think of the predicament. So here, appellate court judgment is, unless it's set aside, how the trial court will take a view which is contrary to the appellate court. This is my view. I am not making an authoritative statement here, but this is what my view is. So therefore, I feel, if I am asked this question, I would feel that setting aside and remanding is the best option. Then one is the judicial officer before whom the matter is placed. His conscience is clear and he hears at a clean slate.
But I'm not on that.
Uh-huh.
I'm trying to point out to one. That will not, the judgment was set aside.
Judgment set aside.
But why will not the trial court pass the judgment again? Then not the earlier issue decided, it decided. He decided only issue number 6. Whether that can be allowed, because I am on the issue.
Oh, achha. Okay, your context is different.
My lord is saying that, my lord, once the remand is made, then my lord, it is better to set aside, because everything goes. Now you decide afresh.
Afresh.
But here is the
Alright.
question, my lord. So there was no substantial question, so I gave a substantial question on that. No substantial question was planned, but my humble submission from my lord is that, my lord, whether once the matter is, my lord, set aside and remanded back, but my lord, at the same time, the judgment says, appellate judgment says that no, you decide this issue and send back the report.
You see the CPC proviso to order 41 rule 2.
But that 41 rule 2.
Proviso. Yes.
Since it's not answered by you, you got, I will have department now. Not answered, now it's- So I do that sufficient opportunity.
So you see, at the time of hearing, if sufficient opportunity is not granted to Mr. Sharma, technically this issue can't be taken up. And second is, if you can kindly come to order 42 rule 1. This is appeal from appellate decree. And it says, rule 1 is procedure.
Yes.
The rules of order 41 shall apply so far as it, as may be, to appellate, to appeals from the appellate decree. So therefore, for second appeal, procedure of 41 is to be followed. 41(2) proviso says that can't be heard unless the side gets sufficient notice. So therefore, you are suffering a handicap on that.
I would say that by hearing the matter, not your fine. There are other substantial question of law. That's not your law to say.
No, but this prohibits, although there would be a judicial pronouncement to do it, but you see, I can't rest my decision without giving anyone a substance.
I'm also not saying,
Uh-huh.
because the opportunity of being hired, that is one of the fundamental
Huh.
principles. I'm not saying that. My submission before my lord, that if my lord finds that it's a substantial question of law, my lord can claim and hear the matter. It's not that without giving them opportunity, definitely only hearing me and my lord can set aside the matter, it can't be. That I'm not saying. But
Okay.
whether it will be at all required or not to my lord to go to that. My submission here will be. But they relied on, the cell deed, exhibit 1. But their claim is that the land was purchased, no cell deed, exhibit 1.
But in this context, you are referring to the permissive possession. Okay, okay.
Possessive position will come later.
No, because since you raised that question, I'm just showing it to you.
That issue was also decided against me. I'm in fact, I'm the permissive occupier.
No, it can't be. You're the defendant,
I'm the defendant and it was held, in,
para 15. Sorry, page 15,
case 50.
para 6.
Yes.
Middle, this defendants particularly denied that the suit land shown in schedule A of the plaintiff belongs to the plaintiff. Page 15 of the memo.
Memo of appeal.
Huh.
Then the statements made by Paravan and so.
Huh, huh,
These defendants particularly deny
huh.
that the suit land shown in schedule A of the plan belongs to plaintiff and that the plaintiff has a right to an interest.
So permissive occupier will not come. If you deny the title, then you see, I can't tell you, just go and occupy the, what do you call this, Lata Seal field. So that will not be a permissive occupier,
Both the pleas can't be taken together.
can't be taken together.
That's the, and that issue has been decided that no, I am the permissive occupier. Because after the remand, the issue was then, the issue they probably gave evidence of one of the persons and ultimately it was decided.
The finding is contrary to pleadings. But it gives you an advantage. You're otherwise happy with it.
Now, hello, the main aspect of the matter,
Yes.
the Lordship will kindly see, the whole case of the plaintiff is that he purchased the land, white cell deed exhibit 1. So they have produced the cell deed before the court. They say clearly that exhibit 1 is the cell. Even PW1 in his examination chief is stated, so and so exhibit 2 is the The two witnesses, PW3 and PW4, they say that they were the witness to the execution of the deed. Now, they also, the PW3 didn't say anything about execution. He simply said that he was a witness to that and all that, PW4,
Just now, let me record it, otherwise I'll forget.
Huh?
Just let me record it, otherwise I'll forget.
I'll take to my note to that. effect.
Huh. No, no, just during a part of presentation, I'll make a note. But I don't miss it. Context I will not miss if I pen it down. What was that page of the appellate judgment setting aside that page?
So was it 38 minutes? 10 to 2009, the appellate judgment. There are 8 is relevant minute for the purpose of. There are 8 and 9. It's page 42 to 44.
You are defendant number 1.
Number 1. There are 2 defendants. I'll tell you.
Oh, achha, okay,
2 brothers.
okay.
After the death of Father Manikali, the suit was filed on her.
Yes, please repeat again. PW, there's plaintiff, PW is 1, 2, 3.
So I wrote the judgment of the appellate court in this regard.
Yes, yes.
Trial court judgment. So one chapter is over for this.
Huh,
One part is over. One will kindly come to page 45. The trial court judgment after the. So page 48 will be the relevant page where the decision has been given on issue number 6. That issue number 7.
Page,
Page 48, my lord, the relevant parts.
I'm trying to, in the mental, in my mind, I'm trying to protect the vertical opinion formed yesterday. In my mind, I'm trying to protect the opinion I formed yesterday. So that's why these questions.
Well, I'll come to that.
No issue.
But that is very vital.
No, I am not saying that. I'm just giving an indication. You may make your presentation. I'm not stopping you from doing it. I'm just indicating. Because when I'm hearing, I'm forming an opinion and going out. So,
I have marked it. Right. Unless and until, my lord, I can change it, my lord. Or the other side, not your lordship.
can prevail over you.
My lord, Page 48.
Yes, I am there.
On 17 issue, 17 to 2000, another issue has been said by directed by the Honorable First Appellate Court, whether the defendants are permissive of a value so land. Issue number 1 to 6 were already decided by this court as per the direction of the Honorable Court. I have to decide the newly framed issue, that is whether the defendants are permissive of a value so land. So, the other issue, it says that, since I have already decided, I am not deciding it. I have heard learned counsel for both sides, I am not going to decide the issue. While dealing with the issue number 4, which relates to whether the plaintiff is entitled to the degree of right taken interest of the suit, issue number 5 relates to whether the plaintiff is entitled to a degree of past position. Issued by evicting defendants. Degree of permanent injunction against the defendant, thereby restraining defendants from entering into suit. And the court had to come into conclusion that since exhibit 1 has been proved by the plaintiff, therefore it is enough to have that plaintiff has right taken interest over the suit. One of the other argument which I was making, Lord.
Just a moment. Please put this on. SCC.
Yes.
Huh? I'll show it to you. Just a moment. Find the name, nominal. Find the name. It is Manbodhan, Manbodhan. Huh. Acha, just okay, I've got it. Find the citation. It's AR 1957, SC 912. This is the authority on the point that the mere breach of the directory condition of the order would not invalidate the order. And in this, decision, it has been stated that if on order of remand, that there is a specific direction for only one issue, non-deciding of the other issues is not fatal. This is just come go above. 1, 2, 3, 4, 5 judge. This is a constitution bench judgment. You see that. There was the last paragraph. Prabhakar Anduran. Just take me time to find out because uh, I'm revising this issue after a very long time. A few decisions I've forgotten, so it's taking me some time. There's again another judgment of the Supreme Court. Let me find it out. The citation is there, but let me find that observations. This is also again a special bench judgment of 5 judges. Because in this case which I'm now searching, it's a small observation that I have to find out where in the judgment. It only merely says 2 lines that when a case is remanded, then the entire judgment need not be revisited. I'm just finding out the context. Just give me 2 minutes.
That is there, Lordship, kindly, I'm just pinpointing.
Huh, huh.
The difference between order 41, rule 23, capital A, and order 41, rule 25 is that. Basic. That is the difference between what I am trying to point out to my. That will not, if the suit is set aside, if the judgment is set aside and the matter is remanded, then it is a remand under order 41, rule 23, capital A. That is my submission. And if the judgment is not set aside, but it simply says that no, this issue should have been framed. So kindly frame the issue on this count, take additional evidence, and give your finding, send your finding to me. So that will be remand under order 41, rule 20. That is basic, I am not on that. Here, in the judgment, it was set aside. At the same time, saying that no, frame the issue, take additional evidence, and send the
That is 21.
No, that is order 41, rule 25. Court has the power to do both, it's not that, In a suit decided on preliminary question, order 41, rule 23 will apply. So 23A was introduced later.
Okay,
So it may not detain my lord to proceed your further.
I-
It will not, because.
no, you're right, your proposition is right, I'm just trying to.
Opposition was
find
I'm
it.
saying, I'm not saying, but in fact, no substantial question of law was then problem at that point of time when I gave it. I'm just pinpointing,
Uh-huh,
it is my
right,
duty to point out.
Right, right.
But normally it should not. Now.
Yes, unless the court gives a reason not to, not to act contrary to the appellate judgment.
So because two directions are there. Setting aside the judgment, then saying that no, you frame issue on this, take additional evidence and record your finding and send it back to me. So these both can't go together.
Correct.
But now Malord may say that no, even if that is done, it cannot vitiate the entire judgment. That Malord is.
Yes, in fact, that is the line which I'm, what you call, that's why I'm searching of those cases.
I'll try to find out, I have
Hmm.
not looked into this aspect of the matter. Now, what I was, taking my service.
You have heard of that, it came in the newspapers that ChatGPT was used. ChatGPT was used by a lawyer and then incorrect citations came.
I have read it.
You have read it.
I have read
I can show you now.
I have read it.
I'm showing you it right now.
I have
But
read
that's
it
why
and
it's-
I was telling to people, that it is not reliable.
No, at times it is because I've been using it for quite some time now.
I have read in newspaper.
No, I'll show you this. But the citations which are being referred, I'm not finding it. I'm using AI.
I'm not saying that artificial intelligence is not working and all that. But sometimes it also commits mistake.
Yes.
It can't be absolutely reliable, I think.
You see this passage which I've opened up. 3 decisions given. There are 3 decisions given. No, but in those judgments, this text is not there. That's why I was searching, it was taking me time. Where I was thinking it was there, and so therefore it took me some time to find out. Otherwise, I would have. It's issue, but I'm searching it just for my own satisfaction. If an issue is raised, huh? No, because if an issue is taken, mentally I have to get an answer. Otherwise, it keeps on haunting.
You're not able to decide it.
It-
Citation is not coming.
It doesn't give that satisfaction. That's why that mistake in that what do you call Airbus case. Same thing happened because the citation is not there, but it appears to be so convincing.
Convincing, but the first paragraph itself.
Huh.
And the last conclusion. Because the 2 other paragraphs are not a case where set aside and remand. But the first paragraph it says set aside and remand. Then ultimately it concluded no. In the case of set aside and remand, the trial court has the discretion to decide not the only issue, but to decide the only addition into the issue.
So that's why at times when I do that
If
research,
that is the law or not, then my argument to this aspect is no issue.
no, that's why, but I'm not finding it. So
That's right. Come on.
because when but I must be very sure when I'm using artificial intelligence. Yes.
Now, I'm coming to the basic issue. The
Yes.
core issue is the sale of the land. Where they claim that right title interest. And once right title interest is that the for cost position. In para 3 of the plain.
No, just give me your presentation again, that you said that PW 1, 2, and 3, and then you
That-
said,
That I was telling you, Lord, in the context of exhibit one.
exhibit 1, yes.
So because that is the core issue, my lord.
Exhibit 1 is the cell deed.
Whereby, my lord, the plaintiff, claims to have purchased the land from one Kaifitullah alias Kaifuddin. 1 katha, 14 acres of land. And in the sale deed, reference of another sale deed is there.
Yes. You pointed out yesterday. 1187. Yes,
Now, their case is that they purchased the land. Then, after purchasing the land, he was residing about 1 kilometer from the land. He was a master at that point of time. Then Manikali was his friend and all that, the father of the defendant. Then he went there and said that you kindly look after it. So Manikali later on said that you allow me to have some 2 houses and all that. So that was allowed. So ultimately, when they started constructing something, Pakka construction and all that, then he objected and thereafter notice is issued and other things and ultimately super right. So this is, I'm giving this source. Now, the case of the defendant as projected in the written statement.
so according to you, as per exhibit 1, they could prove the purchase or not?
The execution has not been. Executing of the document. But, PW1 says exhibit 1 is the sale deed. He didn't say that the Kapatullah and all that, the signature of Kapatullah, the signature of the 2 witnesses. Now, PW2, PW3 is the allotment. And he was not the allotment at the time when they claimed that position was handed over. PW3 is one of the signatories, his name so. PW4 is also one of the signatories, witness they claim. Now, PW3 has not said anything about exhibit 1.
PW 2, 3, and 4 are witnesses.
3 and 4.
3 and 4.
They claim, that they are the witnesses. Three is Abidul Rahman.
You say that the signature of the vendor was not proved.
And they are not even their signature. PW4 very specifically says. Very specifically, he states about exhibit 1. He very specifically says that I identified Kafatullah. In the deed, because there is a in the back side of this first page of the sale deed, identification is required from a person. Now he neither proved the signature of Kafatullah nor his signature. Merely they have stated that exhibit 1 is the sale deed. If your lordship kindly. And my case in the written statement. So in paragraph 7. The paragraph 6 also. My lord has only read that part. I have read also paragraph 6 that suit land denial belongs to the plaintiff and the plaintiff has a right to take an interest of himself. That denial is there. Paragraph 7 very specifically, it is particularly denied that Kafatullah had denied that Kafatullah had absolute and exclusive right to alienate the suit land by way of sale, mortgage, etc. Page 15, paragraph 7. Then para 8, that in reply to amendments made in para 3 of the plaintiff, it is submitted that Muhammad Saifuddin had no authority right to sell the fruitland by the registered sale deed number 24. It is particularly denied that plaintiff got delivery of the vacant half portion of the fruitland from the vendor so and so specific demarcation. These are second. Has been made sufficient much Saifuddin had no authority to sell this fruitland. Well, this was not very specifically said. In that context, from my humble submission, that deed 118.
117,
No, 117 is the deed which Tafatullah told.
1187.
118. Because that has been referred in the deed. In the exhibit 1. 1811.
1811, huh? 1811.
Has been made sufficient damage if Saifuddin had no authority to sell the fruitland. So this was basically the case that has been projected by the defendant. And then our cases are
But
there.
I've still not been able to follow. The reference to 1877,
1811.
1811, huh? Okay, 1811. Is the purchase deed of the vendor. Now he says that this Kafiullah did not have the authority to sell.
Yes.
So how does it disprove the title according to you?
But if he does not have the authority to sell the land, even the right title interest will not pass on.
No, but he was he's the son of the original owner.
Yeah.
Kafiullah is the son of the original owner.
So he has not said that Kafiullah is the son of the original. That is not the case. Marot will kindly see the
No,
son
no,
of
it's
the
there.
original, son of the original owner are there, 6%.
Just a moment.
They are not subject to correction.
No, just a moment.
That was put in evidence. Page 20. Our case.
Oh, no, he was not the son because he purchased it.
He purchased somebody, he has not proved from
He-
whom he has purchased.
The name of Kaifuddin and Lutfur was mutated on the strength of sale deed number 1811.
The somebody is looking to Jamabandi.
No, yesterday's notes.
So in the Jamabandi,
Yeah.
not subject to correction, I have a copy, but I have found a type copy is there. But the entry, note in the.
Entry was on the same day. The purchaser and the vendor
No,
entries on the same day.
But nothing has been mentioned there. They said Kharida Putre. Exhibit 2, your lordship kindly take.
Exhibit 2 is the patta.
Exhibit 2 is not Patta, Jamabandi.
Exhibit 2.
They say Jamabandi. Certified copy of Jamabandi, security Patta number under Sharabari Moja Bohaigaon, Center. I have a certified copy, but I have seen that type copy, printed copy is there.
Yes, exhibit 2. Jamabandi.
Jamabandi.
No. Something is wrong.
It has
Something is wrong. Something is wrong. No, so somewhere, because I've written the note, I think from the evidence it says, exhibit 2, patta.
But I have not, the Lordship will kindly see,
No, I don't know. Yesterday I have noted it, so
Who introduced to them?
I don't know, some witness somewhere.
But I'll check and my lord, I'll point out to my lord. That is-
In the cross examination, it says that I have no idea whether it was partitioned or not.
Yes. In the
এই প্ৰদৰ্শক দুই খনত মাটি বিভাগ বাটোৱাৰা হৈছে নে নাই মই নাজানো। I'll just check out because if
one in the, he said that exhibit 2 is the certified copy of Javamandi, comma, patta number 118, Gohaigao, Serabari Mulja.
since I have recorded from the cross examination,
Of PW1 below.
so therefore, yes, I must have got somewhere.
So definitely. প্ৰদৰ্শক দুইখনৰ মাটি বিলাকত ভাগ বতৰা হৈছে নে নাই মই নাজানো। That is মিলৰ PW1 cross examination in this.
No, then I'm wrong. Then I'm wrong. It's not Patta, it is Jahabandi. No, because if I noted it, I'll remember it. So if I have made a wrong note, I have to correct it. Otherwise,
It will remain.
it will remain.
But I have not found subject to correction, Your Honor. I have read.
No, may not be because you are right. It is Jahabandi. It's not there.
Because you know, to that extent, you know, the cross examination was also there. Because you know, if the entire, you know, Javamandi is looked into, so that was the, one of the plea of the defendant, that no land was there, that can be sold. And in that Javamandi, they say that Sikhar Sakto Bifayar 12/4/2002 তারিখৰ হুকুম মতে এই পট্টাৰ 177 নম্বৰ দাগৰ 1 বিঘা 3 কঠা 9 এচাম জমিৰ মধ্যে 1 কঠা 12 এচাম মাটি শিক্ষাৰ চক্ৰ বিষয়াৰ 2-3-91 তারিখ হুকুম মতে পট্টা নম্বৰ 177 দাগৰ 1 বিঘা 3 কঠা 9 এচাম মাটি 1 কঠা 14 লতা মাটি খৰিদা সূত্ৰে 7 নম্বৰ স্থলত 24 নম্বৰৰ নাম নামজাৰি ভুক্ত কৰা হৈছে। Then second is
It is of which date, entry of which date?
date is my lord,
2003,
no, the date is 2/3/1991.
2391.
Bail bid is of 29/1/2009.
No, these vendors, both the vendors' name was entered on the same day.
So that's true. but
So
that is
that, what is the date? That's
but date is 2/3/91.
2391. That's just wrong.
My lord, I cannot refer to page, my lord, because my.
Oh, it's okay.
May not tell you this, my lord. But, I have taken.
2391, yes, I got it. So this now, so position,
24 number is the Kafetullah, the vendor,
okay.
in the Javamandi. So your lordship kindly look into the first page. Not first page, but the names are there, Kafetullah. Then 25 is Lutfur Rahman. ইমান 1 তাৰিখৰ হুকুমত পট্টা নম্বৰ ইমানৰ দাগৰ 1 বিঘা ইমান মধ্যে সদলতা মাটির
নম্বর স্থল 8 নং is Sri Boliram Bora. What is the name? It's striked. Boliram Bora.
হরিরাম
Huh?
Handler of Kapil.
Yes.
He is number 7, you know, in the
7.
Mohira.
Oh,
Hariram, as per this, you know, Jamabandi, he purchased 1 kata 14 lakhs.
but his Namjari order is again something very questionable.
That's true.
His Namjari order is that
I am marked it.
Logot,
ইমান নম্বর হুকুমতে 17 ইমান কথা রেখা মাটি
not Logot.
আশরাফ আলী লগত
হ্যাঁ,
হরিদ্রা হতে শ্রী বলিরাম বড়ার হরুরাম নামজারি হয় আশরাফ আলী লগত
Logot.
Had it been in place of Akpala,
It shouldn't start, because otherwise what happens, Mr. Sharma, you'll also have to answer. Because if because of this Namjari order, what you call, things are changing. The Namjari is Logot.
This some proportion of land has been with the handler.
Then Mr. Agarwal is right. Then the sellable right is not there. Your said it goes. The judgment all throughout is incorrect.
So far, Ashraf Ali's name is concerned. It was the original.
No, you see, there is only 1 kata 14 lechas of land which was purchased by Boliram Bora.
Master.
Now his Namjari says that it is along with the vendor. Along with the vendor. Now therefore, ascertainable share can only been shown by the sale deed number 1811. That was not proved. So trial court judgment would be erroneous.
I will show man. I will show man.
You will show, okay. Okay. Yes. Mr. Sharma, there is one more reason to ask you at this stage.
Fine.
Well, since I'm interactive, I won't keep anything to mind. Because I don't want to go home with a feeling that I have not discussed the matter. You see, if I hear it completely, but then the question of remand will never be there. But then I'll decide the matter. Then again, the remand will not occur. So I'm asking this question right now because if that aspect is not proved, the title of the vendor cannot be proved. The consequent sale deed, which is what do you call this?
1981,
117.
117.
117, that loses its veracity. So that's why I'm asking you this question right now. Because if I don't have to go into the merit, then the remand is a very easy way.
But this is still, I don't need remand.
No. That's why you see, if that is admitted, then it has to be ascertained.
That
But if it is,
cover.
but if it is not, what you call, if Mr. Sharma has an answer to it, then we go enter into the merit. What I'm pointing it out to both sides is that once I enter into the merit, then no question of remand. Then the issue will be adjudicated. Okay. No, it's okay. You take your turn when it comes. I just pointed out to you. Yes. I think other matters will not be taken up. We will not have time. This is going to consume some time. Huh? Motion is there. Then I think we'll take up the motion first. Huh.
I am putting up to my.
No, it's okay. No, it's okay. Thank you. But then we'll take those motions up.
Two motions, I think. Yeah.
I did not notice.
I will not take for 5-10 minutes.
Hmm?
I will dispose of the motion matter or.
Yes. I'll take up the motion matters then.
So that we can freely continue.
Yes.
I may seek your.
May just point out one thing. But I will be corrected to that. No, the practice of hearing the top of the list will not.
No, there are reasons for it.
No difficulty will not. I notice hearing the top of the list priority is there because 2009, 2007 are pending, not disposed of. We are happy actually these matters are disposed of. But difficulty is that a person having motions and all that.
No, we can't avoid it. You see, what is happening is in my courtroom, I can't say of others, but in my courtroom, what has happened for last about more than 6 months, whenever a part 2 list is there, I have to dismiss it for default, but nobody is there for hearing. I think in the last last 2 months, this practice has stopped.
Right.
Prior to that 6 months, if you look at my part 2 list, you will find the matters either dismissed for default or and on in a serial call. The lawyers present maybe in 1 or 2. So part 2 list is falling, and this has happened. I am one of the causes of this happening, because 2 days I had to rise up from the courtroom. One day on 10:45, and on the other day it was about 11:30 or so. The board fell, and I had to rise. And then when we discussed, I found that this is a regular phenomenon in all the courts.
Yes.
And therefore, before this happened, in this courtroom, I had asked the lawyers to find out a way where we can have this all matters heard. So we did not want ourselves to be imposed, because we wanted a solution from the bar. The president of the bar was also here. We told him to suggest something so that effectively you can take up the matters. But since no decision was communicated, then we had to take this decision, because 2000 old matters, nobody is ready to do it. I'm not accusing you of anything, but what I'm trying to tell you is that we have to be coercive and then hear the matter. So that is what is happening. So I am also one of the persons responsible for this happening on board, because old matters nobody is touching. So we have to compel
the hearing to be taken up. So that's why. I can only what you call uh, express that I am though not happy, but this is something which we have forced on ourselves. Can be helped. Yes,
If I may seek your lordship's, that it's item 7 of today's list. And that was dismissed for default twice, restored few days back. It has been directed to be listed. Well, it's unlikely to reach today. Well, the problem here is this, that only the writ of execution is waiting to be issued on the 31st of this month, madam. This is a matter, the decree holder's property. There's a judgment from this honorable by my lord on this particular property, another shop room reported in 2017 for GLP 57, my lord. That's the reason, my lord, if this matter can be taken up as soon as possible, my lord, I'm ready to argue. I have further responded the decree. holder.
so we can fix a date, give a date. 2013 matter, otherwise will be taken up.
Suit is of 96, the tenancy is from 1951.
আপনি একটু side of আপনার এটো। I don't think next week there will be any hearing. It will go to after vacation.
Look, that is my prayer.
No, because you see, it will be declared as a motion day.
I understand.
It will be declared as a motion day.
I understand.
Uh,
Only thing as
You give it after vacation, but we'll take it up. Just remind.
Obliged,
7th of November.
deeply obliged.
The court must will take care of it. Here's there's a motion matter, item 3.
Item 3.
I don't, I'm praying for the adjournment of this matter, but can it be listed after vacation?
After vacation,
How for Mr. SP of them?
okay, both sides are after vacation, there will be no live issue to take up. Very unlikely that there will be a live issue to be taken up after vacation.
I am speaking the month of November. This is fixed in the month of November.
Pardon me?
This is fixed in the month of November, fixed.
Item 3.
List on. For positive time matter could not be taken up today, list on. No, that earlier item,
Earlier item, list of 711.
that is item number,
Item number 7.
item 7. And this item 3, so both sides are represented. On the prayer made by learned counsel for the petitioner, list after ensuing vacation.
There may be peaceful.
Why you need the date? Why you need the date? You are the respondent. I fail to understand your urgency. Let it remain after vacation. We are very hard times to manage the board.
Motion item 16.
May I tell the laws?
From this is the financial life maintenance matter, my love, it is directed to both the person, not mediate. And the mediation without.
This order was made online yesterday only.
My lord, issue is that, I have come to know from my respected friend that the mediation has been appointed yesterday mediator, and it is fixed on 1/11. For report of the mediator.
So we listed after vacation then.
My lord,
If mediator has been appointed, that we can give some time. Okay.
Mayor, pray, Milord, that the impugn order, Milord, which I am challenging, can it be stayed for that moment?
What is the impugn order?
But the impugn order is regarding that the maintenance should be paid from the filing of the conjunctive like petition or not. The learned court below had held that it should be from the, Milord, date of filing of the petition, conjunctive like maintenance. That we are raising that as the honorable high court. Milord, this honorable court has modified the original order. But from the date of modification, may have not into effect. Very short issue, Milord. And in the meantime, Milord, we are paying the, Milord, regular monthly of 15,000 per month. That I will pay. Is 18, Milord.
Page.
80. Effective position is just 81.
You're paying 30,000 per month now.
No, Milord, I am 15,000, Milord, what has happened, Milord, originally it had been directed that I should pay 30,000 as a whole to my wife, Milord. Then, Milord, that original order had been put into challenge, and this honorable court had bifurcated that 15,000 I should pay to my wife, Milord, and the rest, 15,000 that I should spend on behalf of my child, by myself. That is the modification had been made. And now, Milord, we have said that as the order had been modified on this state day. So, Milord, from that day, this liability should belong to for payment of maintenance. Should come. On this-
What is the cost impact? How much money it comes to?
But around 1 lakh something is the.
On
1 lakh,
1 lakh.
1 lakh and so.
1 lakh something as a year.
Third, one thing which I would like to say is that it is not 15,000. Quoted, this honorable court had said that 15,000 will be towards maintenance of the wife and 15,000 for children. Moreover,
No.
the learned child-
No, it says monthly education expenses for 2 children.
Yes, sir.
That I will bear, that is the direction of this honorable court. Now, the learned court below has also misconstrued, Milord, that bifurcation learned court below has negated of this honorable court's order, Milord, original order. That we are also raising, Milord, in this petition. I don't may decide the issue, Milord, because, Milord, this petitioner and in the mediation, Milord, yesterday the petitioner.
It's okay. Once mediation is there, we postpone this decision till next day.
Fine.
The enforcement is
But till date, he has not paid.
No,
The area, so
area
here
I
I
have
have
not
question
paid.
of stay. Right, because he again will stop paying this.
No, I will have to.
no. You see, that's not his prayer. Mr. Bhuya is praying that the payment of the area be stayed, not the current one.
That can be decided in mediation.
Uh, So here we are on counsel for the petitioner. And Mr. A. Bhatra and counsel for the respondent have jointly submitted that pursuant to order dated 9/10/2023 passed by this court, comma, mediator has been appointed to settle the dispute between the parties through mediation. And the mediation proceedings would be next taken up on 1/11/2023. Full stop. Next one, it is further submitted that the learned trial court had directed by the impugn order. By the impugn order, the trial court has directed the petitioner
to pay area monthly maintenance from the date of filing of the maintenance petition. So it is submitted that the said order is under challenge as the petitioner is claiming that the said order of maintenance as announced by this court should be payable from the date of the order of this court. Next panel. The prayer for stay is opposed by the learned counsel for the respondent. Next panel. In view of the nature of issue raised in this revision, come on, let a formal notice returnable on, give a fixed date after vacation. 4 weeks. 4 or 5 weeks, wherever it's. Give it in a motion day, not in the hearing day. 22/11/2023. First of as the learned counsel for the respondent has already entered appearance through by filing caveat, steps is issuance of steps is are not required. First off, in view of the mediation, which has been initiated in this case before the mediation center in Dibrugarh.
Yes.
The enforcement of the order of maintenance from date anterior to the order of this court dated
Eleven, 2020.
2/11/2022, passed in
Take case number 37 of 2022.
shall remain suspended. Full stop. Next para. The interim order passed today shall be revisited on the next date of listing. Oh, okay, next para. The nonetheless, it is provided that the current maintenance shall continue to be paid by the petitioner to the respondent. Timely each month.
Same on the
It's okay. I'm not disbelieving you.
I know.
Yes, Mr. Agarwal. You should be happy that we are giving you rest.
I don't want to sit on that.
7, we have fixed a date. After vacation, we have fixed a date.
7/11, 7th of November. 7th of November.
I have checked the second Jamabandi which we have exhibited. That also says a lot.
Lower. No, those will not change, but
And I thought I'll just speak for another aspect of the matter before I go to further. Like a Lordship kindly up to page. The paper, sorry, memo of appeal. Page 20.
20.
Page 20. So who were the original owners? Original Pattas also did it. I just pinpoint to my lord. Ashraf Ali was one of the persons who was also the
20.
20. Para 16.
16, yes.
There is food land along with the other land covered by the patta in this food originally belonged to late Nur Muhammad.
Huh.
After the death of Nur Muhammad, his 5 sons, Taksnur, Ashraf Ali, Kumar Ali, Faizuddin, this Faizuddin is not this Faizuddin, not the uncle Faizuddin, and Manik Ali, who is the father of the defendant, got entirely by way of gift and their names are entered in the records of right. And if you looks into the Jawabandi from 1 to 6. 1 is Nur Muhammad, then after that 5 have come. We have taken a point also. That if you lordship go through the Jamabandi. The land which they said that they have sold, it was not available for sale. If need be, we will not try to prepare a chart. So. I was on the evidence of PW 1, 3 and 4. The sale deed, so lordship kindly take, I have given. Paper book also, my lord, my lord can take it.
Just a moment.
Huh?
Just a moment. You privacy appear to be right. These are facts would become irreconcilable. The facts, the documentary evidence and the documentary evidence favors you in that submission. You know, Mr. Sharma, why I'm saying so? But why I'm accepting that argument of Mr. Agarwal? Are you aware why I'm accepting that argument?
So for my, land.
Mr. Agarwal says that the land which was sold was not even available. He has a very strong point on that.
I have gone to the madam exhibit two. I have gone to the exhibit two, madam. You cannot take the note,
I'll tell you.
77, madam.
I'll tell you. You have the copy of sale deed with you, exhibit 1. Come to page 4 of that sale deed. You have page 4,
Yes, ma'am.
sale deed. So and so গাঁৱৰ 118 নং 30 সোনিয়া মেয়াদি পাট্টাৰ 174 দাগ জাবত 1 বিঘা 3 কঠা নলেচা মাটিৰ 1 কঠা 14 লেচা so বিক্রি করা হল, correct?
My lord is reading the note. Okay, my lord, I'm sorry.
Sale deed, original sale deed, page 4.
Here I am on the.
It starts with, because my page will not work.
Tafsil. Schedule of that land.
Yeah, schedule. Yeah. Tafsil. Yes, no, primary, Anna, Tata, Regina.
1 বিঘা 3 কঠা নলেচা
একাত্তর পর 30 সোনা মেয়াদি অর্থাৎ 177 ডাগর তার 1 কঠা 3
না this is 1 বিঘা 3 কঠা 9 লেচা,
আচ্ছা
correct?
মধ্যে
Now this is here it says that out of this land 139. Now in the Jamabandi the dag of 174
consists of 1 bigha, 1 katha, 11 lechas.
So that was put to him. That was suggestion was put to him. He said, I do not. In evidence, that suggestion was put to him. My lord, your lordship will find, বছৰীয়া মাটি 177 জাগত মাটি এই জাগত মুঠ মাটি 1 বিঘা 1 কঠা 11 লচা আছে যদি নাজানে that question was put very specifically.
No, you have to respond to it. I'm just putting it out.
Yes.
But this would be a specific question you have to
I
answer.
have noted it down. Fine.
Okay. So what is the difference between two? 111, this is sorry,
One katha,
139 minus 111, 11 is how much?
It will be around 2 katha.
Around 2 katha.
139 and 1111. It will be 1 katha 18 less.
1 katha, 18 lechas. Okay.
That specific question was put to him. He said that I do not. So I will also take note of that, that question was put to him.
PW?
PW1. Rahman.
Yes.
Then his evidence also in prosecution, he says, পদক্ষেপ 2 খনৰ মাটিৰ বিলাকৰ ভাগ বটোৱাৰা হৈছে নে নাই মই নাজানো এই পট্টাদাৰ সকলক বছৰত পাৰ্টি কৰা নাই then I can skip this is very important, this suggestion was very important question. Karafat বর্তমান মৃত, he died. Somebody says that nobody knows at what time, what point of time he died. But PW1 cross-examination.
If you have made a type copy, you will have to give it to me.
No time.
Acha, you are reading from
I
that.
have given a copy. This set has been given to my lord.
Ha.
That is there with us. I can refer to the pages in my copy also. I have given 2 sets, my lord. One of the position of plaintiff and defendant, and one of list of documents. It was given long back, my lord. The matter was once the hearing list, the part 2.
No, if you have given, it will be available.
I find it difficult to read from here and there.
Huh.
So I always do, make myself itself so that.
No, it's available.
So let's take the deposition volume, my lord.
Huh.
And my lord, may I take to my lord page 9, my lord.
9, yes.
In page 8, my lord, he has given, my lord, that who are the sons of Nur Muhammad and all that, that is there, my lord, I am skipping. Next page, বছৰীয়া মাটি এখন দাগৰ মাটি এই দাগত মুঠ ইমান মাটি 1 বিঘা 1 কঠা 11 লচা আছে যদি মই নাজানো then my lord can skip over.
Just a moment.
Then regarding
Just a moment. Yes.
my lord will now go down below window. It will line about 1, 2, 3, 4, 5, 6 line from down.
Yes.
My lord, Kerafat বর্তমান মৃত. So the person who sold the vendor.
Kerafat, huh?
তেওঁ কাৰ পৰা মই কিনা মাটিটো কিনিছিল তাৰ কাগজ পত্ৰ আদালতত জমা দিয়া নাই. Why I am referring to 1181. So that is important in view of my mirror stand taken in the তাৰপিছত 19/1/90 চনত কাৰাফাত উৰুফে কাইফুদ্দিনৰ মাটিত মূল বিক্ৰী কৰাৰ অধিকাৰ আছিল নে নাই নাজানো। কাৰাফাতৰ মাটি বিক্ৰী কৰাৰ স্বত্ব আছিল নে নাই নাজানো।
What would be English of Sattva is it will be ownership or it will be title? English of Sattva Asil Nai Sattva will be title or right?
Right.
Right.
One is sale, right to sell. Another is after বিক্রি করার সত্ত্ব আছে না নাই।
So this word used here would indicate what? It will be right, title or interest.
Will not- That is the will not here.
Huh?
That is right, that is the intent.
Yes.
Other suggestions I am not reading, so that's not relevant, but your lordship will, yeah, input there. Thank you. Then my lord will next come to page 11. The lordship will find in line about 1, 2, 3, 4, 5, 6, 7, 8. Lordship will from 6 line onward. মানিক আলী বন্ধু হিচাপে মাটিটো চোৱা চিতা কৰিবলৈ দিছিলো আৰু দিওঁতে কোনো উপস্থিত নাছিল। মানিক আলী বছৰীয়া
No, just one. Page 11. Yes.
7th line.
হ্যাঁ,
চোৱা চিতা
মানিক আলী বন্ধু হিসাবে।
হ্যাঁ।
মানিক আলী বন্ধু হিসাবে।
চিতা কৰিবলৈ দিছিলো আৰু দিওঁতে কোনো উপস্থিত নাছিল। মানিক আলী বছৰীয়া মাটিত ব্যৱসায়িক বাবে ঘৰ কৰিবলৈ অনুমতি বিচাৰোতে কোনো নাছিল। এইটো কথা সঁচা ন, দিছ ইজ ইম্পৰ্টেণ্ট। এইটো কথা সঁচা, মই মানিক আলীক মাটিটো চোৱা চিতা কৰিবলৈ অনুৰোধ কৰা নাছিল। But I have checked in the original also. I thought that there may be some, it is Bhakta Nohai, something will be there, but that is not there. এইটো কথা সঁচা, মই মানিক আলীক মাটিটো চোৱা চিতা কৰিবলৈ অনুৰোধ কৰা নাছিল। So that is this case. That I have asked him to see. Then when I used to go to his house, one day he said that no, allow me to have to extra houses so that I can do some business here. But you know, you will find this line in page 5, page 77 of the record. Now, this is the evidence of PW1. I am skipping PW2 because he was a lot mandal. He gave a evidence, he was not there with lot mandal at that time. only one estate. কিন্তু শিক্ষক নামজারি সূত্রে হওয়া শিক্ষা নামজারি দখল খায় নামজারি করা হয়। And I'm just showing page 14. Okay. Ninth line.
A2 Chita,
A2
নামজারি।
Ninth line, A2 শিক্ষক নামজারি নামজারি সূত্রে হওয়া। I do not know what is. শিক্ষা নামজারি দখল খায় নামজারি করা হয়। শিক্ষা বহিত A2 next থাকে যে কতজন পিতা সহিত আর পুরো নাম লেখা আছে।
A2 Chita নামজারি হতে হুয়া, ঠিক আছে, ওকে।
যোৱা 6 বছৰ ধৰি মাটিত খাদ্যুদ্দিন দখল আছে। এই দখল মই মোৰ অঞ্চলত চাকৰি কালত দেখিছো। মই
You have seen what you call this note printing machine at Devas. You have seen the note printing machine? No, this is the note printing machine. A Sitha Namjari hote hua. That is a note printing machine. You go there, he is satisfied, he enters the name in the Namjari, assistant settlement officer, records in the chitta, and anybody becomes the owner. So that is the money printing machine. Hmm.
This is happening. Money printing machine, I have understood. I have lately understood what you are saying. You are equities.
Huh?
Generally, nowadays, this well versed engineers like us.
Pardon me?
Nowadays, we are well versed with the procedure adopted by the law.
We have all had our share of experience.
I myself.
We have all had our share of experiences. Less said is better.
I have not approached my law, but in my case also, I have faced such a situation.
This happens, better not to say.
Better not to say.
Happens. My lord, I'll give you a small example. My lord, why people do not want to come to the court. My personal experience and but I have fought with the telephone department and other departments. But they rejected me now there. Ultimately, having fought for 2-3 years, ultimately what we will get? 50 rupees, 60 rupees refund. I thought it is better not to do because I have funded my 2 years for nothing.
Correct.
My lord,
Oh, I am sorry, Mr. Agarwal. I have to rise. There's a meeting at 4:30.
but, tomorrow will continue.
No, not tomorrow. কেতিয়া দিব পাৰিম?
Next week to motion देगा.
Yes, that's the difficulty.
Next day. Ninth of November.
এটা কাম কৰক, নেক্সট উইক দি দিয়ক এটা, তাৰপিছত নহ'লে তাৰপিছত চেঞ্জ কৰিম।
Thursday.
No, not Thursday. I think we'll take it up Tuesday.
It's 17th, 1710.
17:10. Because if not, otherwise it gets spilled over. Let me have a try.
I just informed to my lord. Let it be listed. I am likely to go out.
Okay,
If I am not there, the dimension will be made my lord.
okay, just,
Let it be there, my lord. Let it be there.
no, it's okay, just,
We'll try to finish it sooner, it will be better, because my lord may forget later on also.
if you make a prayer for adjournment, Mr. Agarwal, if you make a prayer of adjournment, please take consent of Mr. Sharma. Give
I'm
your,
informing my lord anything.
no, it's okay, it's good. Mr. Sharma, share your telephone number. Share your telephone number so that you can be informed.
I am having this number also, my.
Okay. The submissions of Mr.
K. Agarwal, Senior Counsel, assisted by Mr. D. Akram. No, it's okay. And Ms. P. Devi, P. Nyog, remains inconclusive. Mr. M. K. Sharma, Run Counsel for the respondent is present. Next date is proposed on 9/11/2023. First of however, the 11th Senior Counsel for the appellant, submits that there is a likelihood of his being out of station, and in that event, he prays that some accommodation be given to him. First of hence, if prayer for adjournment is made on the next day, the other side be informed beforehand. Next list on 9/11/2023. I'm putting on record because otherwise you'll forget. Oh, no, so 1710. I'm putting on record because otherwise I'll forget. If it comes in the top of the list, then the tendency to not to adjourn the matter.
Yesterday I was little whether whether adjournment will be granted or not, because what happens, the client will think that I am not there. These are the difficulties here.
No, difficulties are there, but we are hard pressed.
But we
The old pending cases,
that adjournment could be given as an
old pending cases is creating a huge backlog of old matters, especially in civil side.
Yes.
Criminal, we have been able to be a bit faster, but the civil side is taking a back seat.
I've been also waiting for this method for about 3 months.
Huh?
I've been waiting for this method for about 3 months.
No, everybody, it's not only you. If it is a 2006, 7, 8, 9 matter, everybody is anxious
Once here.
because the parties will always call you and then
Yes.
ask you about the review, but we have some difficulties, can't do anything. You've already seen, even today, you have expressed some reservations in the top of the list, but it
Yeah.
can't. When it comes in the top of the list, there are reservations. It can't be helped. Hello.
Oh.
Hello, this is class.
Oh, no, but it's not.